Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let's do a quick preview of today's docket. First, the new, now most hated man in America, Cleotha Abston-Henderson, has been charged. Is the district attorney in the Lori Vallow matters playing games with turning over discovery to the defense? Have to wait a few more months for the autopsy results for Keily Rodni. More random crime. OnlyFans model case update. An Murdaugh case update. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and remember to hit that little bell so that you receive notifications of when we go live or put up new content. Now, also remember that you can listen to not only this episode, but any episode of Crime Talk by simply downloading us on any of your favorite podcasting apps. All right, let's get straight to the docket for September 7th, 2022. Let's open the docket. First, Cleotha Abston-Henderson is accused of killing elementary school teacher Eliza Fletcher after bundling her into a car on Friday, with prosecutors confirming the pair had never met. Well, he appeared at court today in Memphis, Tennessee. Now he is officially, formally charged with first-degree murder, kidnapping, and tampering with evidence, with the judge refusing to grant him bail. Now, Tennessee is a state with the death penalty, and prosecutors said today that they were not ruling it out if they convict this man. Authorities confirmed that the body found in the long grass near an abandoned property close to where Mr. Abston was seen cleaning his car was that of Miss Fletcher. Now, speaking after the hearing, the Shelby County District Attorney, a guy by the name of Steve Mulroy, confirmed that the incident was isolated and that Fletcher had never met her attacker before that morning. Now, more disturbing news shows from court documents that the violent felon, Cleotha Abston, was previously convicted of raping a man when he was a teenager, as new footage shows the alleged killer cleaning his SUV hours after the billionaire heiress Eliza Fletcher vanished. Now, Abston, who's 38, was just 11 when he first appeared in the Shelby County Juvenile Court in Memphis, Tennessee, charged with theft of property of $500 or less. He was detained 16 times from October of 1995 to May of 2000 for rape, aggravated assault, and unlawful possession of a weapon. His first charges against him in June of 1995, and that he was part of the LMG gang, which stands for the Lemon Garden Gangstas. Records show that Abston was accused of raping a man and was placed in custody of the Shelby County Youth Services Bureau. 2 weeks after he was released from his final stint at the youth facility, he went to his mother's care. He was transferred to an adult court for kidnapping a lawyer at the time by the name of Kemper Durland. Now, Mr. Abston was sentenced to 22 years in prison for that offense. Mr. Abston was released in 2020, obviously just before he allegedly committed yet another violent crime. Now, there's some new footage that shows the suspected killer driving to his brother's home, and his brother's a guy by the name of Mario, at the Longview Garden Apartments complex around 8 a.m. on last Friday morning. Less than 4 hours earlier, Mr. Abston is accused of kidnapping the heiress 7 miles away, close to the University of Memphis. Now, in the video, he can be seen sitting in the car after arriving at the complex before getting up and going to the car's trunk. It's unclear what he was getting from the trunk. Now, authorities in Memphis confirmed that the body found in the long grass near an abandoned property close to where Mr. Abston was seen cleaning his car. And after rummaging around in the vehicle's trunk, Mr. Abston runs into his brother's home before returning to the car and spends more than an hour on the passenger side of the GMC Terrain. Now, Mr. Abston's brother, Mario, described his brother as acting strangely and has been arrested on several felonies that are unrelated to Fletcher's case. Officers found a semi-automatic handgun, a scale with a bag of heroin and fentanyl, and he's been charged with being a convicted felon in possession of firearm, possession of a firearm during the commission of a dangerous felony, and possession of controlled substances. Nice. Now, Mr. Abston told the police that his brother had been cleaning the interior of his GMC Terrain with floor cleaner and washing his clothes in the sink of the house. Cleotha Henderson, Abston's father, is currently in prison for second-degree murder, and he is scheduled to be released in 2044. Another neighbor had also confirmed that Mr. Abston was acting very strange, and police determined that his phone pinged near where Fletcher was taken. Officers removed a dumpster close to Abston's brother's low-income apartment complex over the weekend, and police discovered the missing mother of two in the long grass to where her Lululemon running shorts were found in a trash bag. For those of you who are not familiar with the case, the underlying facts are that Miss Fletcher, who is also an ultra runner, vanished while out for a run around 4:30 a.m. on Friday, sparking a 4-day-long manhunt, which led officers to several wooded areas across Memphis. But she was discovered by the steps of a dilapidated one-story property just yards from where the police last spotted the vehicle she was forced into. A blood stain actually remained at the bottom of the stairs next to the patch of dirt where her body was found, with apparently witnesses saying that there were still flies swarming the area and there was a stench of decay. Now, Mr. Abston, who's accused of taking the jogger, drove with her in his GMC Terrain for an hour and a half before the vehicle was spotted turning into the road where her body was discovered. Now, the area where the body was found is just 100 yards from the Longview Gardens apartment complex where Mr. Abston's brother, Mario, resides. And as we've previously noted, Mr. Abston was only 16 years old when he and an accomplice kidnapped the attorney, Mr. Durland, threw him into his own trunk and tried to force him to withdraw money at a gas station ATM back in 2000. This presents a question: what to do with violent juvenile offenders? Before this young lad even got to the age of majority, he had a sexual assault and a kidnapping. Are you kidding me? Listen, when they grow up to be violent adult offenders, does the juvenile system work? Does it coddle offenders? Can these young people be rehabilitated? Some of the research suggests that violent offenders, if released, should only be released basically when they're too old to be able to harm anyone. Let's face it, sometimes people are just not wired right. They cannot function in society. They cannot control their impulses. Let me know. What are your thoughts in the comments below? Is it time to get back to law and order? Or if we just gave everybody a big hug and a big check, would that take care of all of our problems? We'll have to wait and see. Because remember, Mr. Abston was sentenced to 24 years in prison, but was released early in 2020, according to the Tennessee Department of Corrections. That's right. Miss Fletcher may still be alive today, but for Mr. Abston being released. Something to think about, ladies and gentlemen. I don't have the answers. I don't know. But I was in court the other day, and it really kind of reminded me of something where I thought, it seemed like coming to court was really about whether somebody did something or not did something. And now it feels like a therapy session where everything is about getting somebody the help they need. And I get that, but that's part of the attorney's job to present mitigation. But I'm not sure it's the state's job to come up with all of these solutions for every problem presented out there. I don't know. Once again, let me know your thoughts in the comment below. Next on the docket, are the district attorneys playing games in the Lori Vallow matter as far as turning over discovery? Well, Lori Vallow's attorneys are asking for the court to tell the district attorney to turn documents over. And what do Vallow's attorneys want? They assert in their pleadings that a written request for discovery was made originally back on April 18th of 2022, which included to provide any statements made by co-defendants, any witnesses' statements, witness lists, and a list of witnesses who reside in Arizona, Utah, and Texas, and elsewhere. And apparently some of these witnesses have been in regular contact with the prosecutors or their agents, i.e. the police. It is alleged that these statements have not been disclosed by the prosecution. Is this a discovery violation? Well, normally what takes place is if the defense thinks that something has not been turned over, they ask the prosecutor. The prosecutor then says, oh yeah, hey, let me get that for you. Or they'll say, pound sand, we don't have it, or it's not within my care, custody, and control. And then you say, fine, I'll go get it. But if it's in the possession of the district attorney or the agents that report directly to the district attorney has to go and get it. It's their obligation under the law. Now, the defense is requesting also copies of any immunity agreements that the state has offered to any witness. What is that? Well, that's anything regarding any promises of leniency. We're not going to prosecute you. Hey, if we prosecute you, we're going to give you a really good deal. That all goes under what they call Rule 608 for cross-examination, which is basically any bias, motive to fabricate whatsoever. It all comes in for people to change their stories, to maybe exaggerate a little bit, maybe have a little bit of a faded memory. Could it be because the memory is just faded, or is it because they forgot that particular detail because it doesn't particularly help the defense? Those things need to be turned over. And the defense says, hey, Mr. District Attorney, we also need a good faith witness list. Now, apparently the state has endorsed 104 witnesses, but they've also failed to include any address or contact information. Now, I don't practice law in Idaho, but normally the information that needs to be turned over on a witness list is the name of the witness and their address or telephone number so that you can actually go and interview them. I know it seems like a radical concept, right? It's not. And only if there is some good cause, like for some sort of tampering of witnesses or something, or danger to the witness, would the address be withheld, and it would usually go to the care of the district attorney. And then the district attorney would help you coordinate the address and contact and see if this witness wants to be interviewed by the defense. Once again, here we are 4 months from trial. Why has this not been turned over? And I've mentioned this before. The prosecution has to turn everything over to the defense, good, bad, or ugly for the prosecution's case. Why are these statements, assuming they exist, not being turned over? Now, given the length of time this case has been going on, you would think the whole case had been indexed multiple times, years into this case, and the defense is saying statements are not in our possession. 4 months from trial, ladies and gentlemen. Now, whether this is an honest mistake or playing games, I'm not saying they are. Either way, but come on, prosecution. Now, remember, if the court finds you didn't turn these statements over, and if worse, the court finds that it was bad faith that you didn't turn them over after you possessed them because you thought of some theory why you wouldn't have to turn them over, guess what? Those witnesses could be prohibited from testifying at trial as a sanction for the government's conduct. Or possibly the defense would have to ask for a continuance. And I'm really starting to think maybe it's the prosecution that wants a continuance in this particular case. I've said this before and I'll say it again. Always fear a prosecutor who willingly says, I will give the defense whatever I have, whatever they want. The DAs who play discovery games, it comes back to bite them in the end. So, is the DA playing the games? Honest mistake? Or maybe they're just in over their head? Let me know what you think. Another motion that the defense just recently filed is the defense for Lori Vallow is asking for a bill of particulars. What's a bill of particulars? Well, that's basically as it relates to the whole issue regarding the motion that was apparently argued, since it was done in secrecy, about the whole issue of the charging documents. The defense for Lori Vallow has basically said, hey, Judge, if you're not going to make them go back and charge these charges correctly, we're going to make this record and ask for a bill of particulars and say, Judge, there are multiple theories of prosecution that could be done here, and frankly, we don't know which one to prepare for. And the way it's charged right now, the prosecution could change their theory of prosecution mid-trial if things don't go their particular way. So the defense is saying, you need to give us this information now. And the essence of the bill of particulars are that really there are 3 separate allegations of murder which are alleged to have occurred on 3 separate dates. The conspiracy to commit those crimes were alleged to have occurred over a 2-year period. And there are allegations of grand theft and conspiracy to commit grand theft. There are at least 2 co-conspirators, one of which has been named in the indictment posthumously, and there are known unnamed co-conspirators as well as unknown co-conspirators according to the indictment. Third, the discovery in this case is voluminous, to say the least, and discovery is still ongoing. As of the date of this motion, defense has nearly 5 terabytes of electronic material. And they give an example and say, hey, Judge, just to give the court a flavor of the amount of discovery, a terabyte is approximately 1 trillion bytes of information and could store 1,000 copies of the Encyclopedia Britannica. And much of the discovery has been gathered over several years, and the defense is in the position of sorting through all the discovery, which the prosecution has had in some instances for years. And a bill of particulars would narrow down the possible alternative theories that Ms. Vallow would be required to defend against. They also cite that Ms. Vallow has been incarcerated for over 2 years under conditions that make it difficult to review the technical materials and discovery, and taken together, the factors create a perfect storm of difficulties in preparing for trial. Without a bill of particulars identifying and defining the issues laid out below that the government actually intends to assert a trial, the defense will face an impossible task of preparing to defend against dozens of potential scenarios. Now, yes, granted, the prosecution does not have to tell them exactly what they're going to present as evidence, but guess what? A good prosecutor is going to say, this is what my evidence is going to be. Here it is. Let's narrow this down. Let's do this so that we don't have to have a continuance. Because you know what that motion for bill of particulars is saying, Judge, it's coming down the pike. Judge, I need a continuance. I understand my client won't or doesn't want to waive a speedy trial, and I'm filing this motion over her objection because I have a duty of ethics that makes sure that I provide effective assistance of counsel. And if the attorneys haven't been able to review all of the discovery in the case and to analyze it, to engage in motions practice, one could argue that they were not effective. See where I'm going with this, ladies and gentlemen? Like I said, you can't blame Mr. Archibald and his co-counsel. They just got on the case, okay? And he doesn't seem like the kind of guy that plays a lot of games, but he is laying the groundwork for, hey, Judge, I'm going to be ineffective if you don't help me by having the prosecution lay out a little more specificity what they intend to do at trial. So just saying, good prosecutor will tell you anything you want to know. And finally, the court has set a motions hearing for September 15th, 2022 at 9 a.m. Now, it's uncertain what this motions hearing will be about. Perhaps the motion for a bill of particulars. Unclear whether it's going to be made to the public or if somehow it will, by chance, be closed yet again, because we don't want to cause any embarrassment to anyone during the proceedings. And, we don't want to prevent either side from receiving a fair trial by having a closed and secret hearing. Just saying, something to think about. Let's keep it open to the public. Let's put it out there on the court's channel so we can all watch it. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Next on the docket, It's going to take a little while for the cause of death in the Keily Rodni case. So the Keily Rodni autopsy results may not be released for 2 months after divers who found her claimed it was suspicious. Now, the teen disappeared around 12:30 a.m. on August 6th near the Prosser family campground in Truckee, California, following a wild party attended by about 300 young people. Authorities, including Placer County Sheriff's Office and the FBI, put in thousands of man-hours searching for Keily, but couldn't locate her until volunteer divers traveled to the area to help. Now, her family is apparently eagerly awaiting the results of her autopsy and toxicology tests, but it could be months before they released as divers speculate whether her death was an accident or something that was not an accident. Now, the 6-man team from Oregon speculated whether foul play was involved during the footage released this month, which is titled How We Found Keily Rodni, Murder or Accident. Apparently, they say that she was, quote, in the back of the vehicle. That's according to diver Nick Rinn, and he can be heard saying in the emotional video after the team used sonar technology to locate her car underwater. She's not in the driver's seat. It looks suspicious to me. The vehicle's upside down. One of the windows is halfway down. One window is all the way down. Many who have followed the case have suspected someone else may have been involved, and police are yet to confirm they have spoken to anyone else that they feel could be connected. The investigation is not complete, and it is considered ongoing according to the police. Once the investigation is complete, the release will be pursuant to all privileges and exemptions that may apply, the police say. And we expect the investigation review and redaction process to be completed by November 1 of 2022. And as you may recall, on August 21st, volunteers from the dive team Adventures with Purpose claimed in a Facebook post that they had found Keily's car submerged in an area near the creek. Authorities insisted they had already searched that area of water, but still the expert team had updated technology and a little better skill apparently, and were able to locate her within hours. It was later revealed Keily's body was located in the back of her vehicle, and the video showing the discovery of her silver 2013 Honda CR-V has been shared on YouTube. Now, I think it's a little too early to tell in this particular case. Let me know what you think. Foul play or accident? Who knows? Toxicology may have a lot to do with it, but we'll just have to wait and see. Next, some more random violence. A woman jumped from a moving vehicle to escape a man who reportedly kidnapped her at knife point in Vancouver when she stopped to help him. Now, Jeremy Aleska was identified days after he was arrested in the kidnapping that ended dramatically in the early morning hours this past Saturday following a police chase across part of Washington state. Now, Aleska is accused of abducting the woman, who has not been publicly identified, on Friday evening after she reportedly gave the man water and a ride to the gas station. Hours later, a family in nearby Camas, which is in Clark County, said they were woken up by a woman in distress who was pounding on the door and crying out for help. "I thought he was going to kill me," the woman reportedly said. Local authorities were called to the house, and after a brief police chase, Alexa was located in the victim's vehicle and then taken into custody. He is currently being held on $750,000 of bond. Now, obviously, this frightening ordeal happened less than a day after the mom of two, Eliza Fletcher, was kidnapped in Memphis while jogging on Friday morning. We already talked about her story, but it's a little scary out there, ladies. Be cautious, okay? Take care of yourself. Don't try to do those good deeds, okay? You don't know who you're dealing with. Next, an OnlyFans model case update. A Florida judge on Tuesday denied attempts by the OnlyFans model, Courtney Clenny's attorney, to restrict potential evidence in her upcoming trial on charges that she stabbed her boyfriend to death in their luxury Miami apartment earlier this year. Clenny was arrested in Hawaii last month and brought back to Florida to stand trial for the death of 27-year-old Christian Obumseli in April. Clenny, who is known as Courtney Taylor online, has claimed self-defense, and her defense attorney, Frank Prieto, sought to keep content such as text messages, surveillance video, and explicit photos found on Clenny's phone, content he referred to as sexually explicit and pornographic, saying such content would not be relevant to the case and would interfere with a fair and impartial trial. Quote, "This is going to turn into a circus of media outlets publishing salacious material which have nothing to do with guilt or innocence of the case," Mr. Prieto argued. Another one of the attorneys said that the content from Cleotha's social media accounts is all noise. It just distracts from what this case is really about, which is on what day in April she was fighting for her life, her attorneys claim. She did what she had to do because she was acting in self-defense. But prosecutors and the attorney for the Miami Herald argued against the defense motion. They're asking the court to allow them to control the narrative, Assistant State Attorney Quinnen said during the hearing. Ultimately, Judge Diana Viscaro agreed with the prosecutors. Now, Cleotha's being held without bond, but her attorneys said that they may file a motion for bond as early as this month. The next hearing is now set for December. Next, an update on the Murdaugh case. Yes, it all continues. The South Carolina Circuit Court judge, a guy by the name of Judge Daniel Hall, has issued an order severing defendants in the Mallory Beach wrongful death lawsuit. Now, this is the high-profile civil action that's actually linked to the Murdaugh mess, matters, saga, mayhem, whatever you want to call it. Well, Judge Hall's orders also set an October 10th, 2022 date for the trial against the first defendants. Who are they? Those defendants are the convenience store and the owner, Greg Parker, and his chain, Parker's Kitchen, which is a gas station type of chain. Now, Judge Hall ruled without offering any justification for his decision. He just filed an order stating simply that he had carefully considered the matters and found that a severance was appropriate. Needless to say, the Beach family attorneys, the attorneys for Miss Valerie Beach and their family, Mark Tinsley, who has opposed the severing of defendants in this case, was in the process of weighing his options with his clients. Now, Mr. Tinsley has not ruled out filing an appeal of the judge's order if the judge declines to reconsider. So what does that really mean? Who's severed off? The gas station owners are severed off from all the drama related to the Alec Murdaugh case and Buster Murdaugh, whose ID was used. So it's a big win for the convenience store owners because they don't have to deal with that, and the jury can focus upon their involvement in the case. The problem for the plaintiffs is that now they would have to basically do their case twice. And guess what? Getting witnesses to trial twice, paying experts, all very expensive, assuming the case is on a contingency fee basis. They wanted to do it once, only once. Oh, just kind of like, what was that other case? Oh yeah, Lori Vallow and them, remember? They really wanted to only do it once. So we'll see. They're weighing their decisions, and they'll decide how they're going to proceed, if there is two trials or only one. But as of right now, they've been severed. Now, for those who may not have heard of this case before, this case stems from the February 24th, 2019 boat crash that killed Miss Mallory Beach. She was 19 years old, and she was from Hampton, South Carolina. And the lawsuit obviously kind of connects the Murdaugh family via the late Paul Murdaugh, who was allegedly at the helm of the 17-foot boat as it slammed into a piling near the Archers Creek Bridge just outside of Paris Island, South Carolina. Miss Beach was thrown into the cold water upon the boat's impact, and her body was discovered a week later. Now, the boat, allegedly driven by Paul, belonged to none other than Alec Murdaugh, obviously his dad, and now the former attorney who's accused of killing both Paul and his mother, Maggie Murdaugh. And Alex Murdaugh is also the focus of the obstruction of justice investigation for the alleged action in the aftermath of the boat crash. And some of the alcohol which allegedly contributed to the Murdaugh's severe intoxication was purchased at Parker's Kitchen convenience store in Ridgeland, South Carolina. Paul used a South Carolina's driver's license belonging to his older brother, Buster Murdaugh, to buy the booze. As a result, the store and its owner, convenience store owner Greg Parker, and has him named as a defendant in the lawsuit as well. It just continues to get more and more interesting. I could see why the judge would have ordered the severance. It's going to be a circus. the very limited issue as it relates to selling of the alcohol. I get it, but they don't necessarily need to go into all the other drama, so to speak, of the aftermath. I can understand why the judge could order a severance. Here you have a limited issue as it relates to, did the convenience store owners sell alcohol to minors? That's really the issue. Then the question is, what is their damage? Now, the plaintiffs are going to have to put on a lot of the same evidence throughout the trial that would have been submitted as it relates to the Murdaughs if they were in the suit. But given the fact that Alec Murdaugh is in custody and probably would assert Fifth Amendment rights against self-incrimination, it just seems cleaner to get this case resolved once and for all. And let's face it, there's not going to be that much money left for any civil judgments against the Murdaughs. Anyway, we'll wait and see how things turn out. And finally, our dumb criminal of the day. A young woman who allegedly dined and dashed in the airport claims that she was being harassed by police officers because they had, quote, never seen anyone as pretty as her, end quote. Now, Hind Bustami allegedly went to Chili's at the Las Vegas airport, but left without paying. Needless to say, the restaurant employees called the police and the officers searched for her, and they located her in the vicinity. She's at the airport waiting to depart. Well, the police report says the TSA officials told the officers a female matching the description was observed sleeping near the security checkpoint, hindering their operations. Miss Bustami allegedly left before police arrived, but she was found at the baggage carousel. She then reportedly became belligerent with officers and started saying she was being harassed because the cops had never seen anyone as pretty as her. Bustami allegedly said she was going to spit on all the police officers because they were perverts and they were trying to sexually assault her because, once again, the cops had never seen anyone as good looking as her. She was booked into the Clark County Detention Center on a $1,000 bond. All right, ladies and gentlemen, thanks for watching today. Thanks for listening on our podcast. I want to thank everybody for taking the time to do so. Hope you enjoyed the show. I want to apologize for not doing the live once again last night or our Patreon, but sometimes things come up in the practice of law. I know that pesky thing called the practice of law sometimes has to take priority over doing this. So my apologies. We'll make it up to you. I promise. Have a wonderful day. We'll see you next time on Crime Talk.